atheists, agnostics, long-haired weirdos, short-haired weirdos, vandals, hooligans.
The government, hug the government, love the government, hug the government, love the government, hug the government.
Welcome to The Politics Guys, a place for bipartisan, rational, and civil debate on American politics and policy. I'm Northern Kentucky University political scientist Michael Baranowski. I'm joined today by my conservative counterpart, Cleveland area attorney and defender of freedom, Jay Carson.
Hey, good morning, Mike.
Hey, Jay. So I'm going to try to get through this midweek show. As I was saying you in the break, I was like just full of beans.
You were all worked up.
It's just been a weird few days for a lot of reasons. And so yeah, maybe I shouldn't have had that second cup of coffee. I don't know, but maybe I should have. Maybe I should have a third.
But really, you should go back and read more of the Murthy stuff. I'm gonna say that again.
Okay, fair enough. But so as I mentioned, there were so many Supreme Court. I got to this. I mentioned this briefly at the beginning of the weekend show, but can you recall a time when there were so many? I counted 8, what I would call at least somewhat significant decisions that came out in a 5-day period. And if that's not a record, it's got to be kind of close, wouldn't you think?
Yeah, I think it's up there. I think you and I might disagree on the significance of some of these decisions, right? I think Loper Bright, yeah, that's huge. I think the presidential immunity decision that's going to come out, that'll be huge. I think Murthy could have been huge, but
and I think, I should say that the January 6th one, which we won't be talking about today.
Right. I'd say that's medium.
Yeah. See, I think when I read the media reports of that, just briefly, is I think they're making much more out of it than what it is, because at least in my first read is that still most of the people who were charged under multiple things. And I won't get into details, but I think this has been made out to be a somewhat bigger thing than it actually will be in the end, when something like Loper Bright, because it's more technical, will end up being far more consequential in the long run, which is why we talked about it, first, obviously.
Yeah, but with the January 6th one, it's got the January 6th look, which is sexier.
Exactly.
So,
yeah, exactly.
And it can be sold as the court's bailing out the rioters kind of thing.
So how sexy would you say the Clean Air Act's good neighbor provision is?
Not at all. You're referring, of course, to Ohio versus EPA, which makes this case even hotter, Mike. Is it's a ruling on a stay application, so it's not really ruling on the merits, although it's kind of sort of a ruling, as it indicates sort of which way they think that they're going to go. But the Clean Air Act envisioned a collaborative efforts between state and federal government to regulate air quality. As part of that, as you mentioned, there is sort of this good neighbor provision. This has to do with ground level ozone and the EPA's authority to regulate that across various state lines. And the state of Ohio, and along some other states, said that this regulation was essentially arbitrary and capricious, which, if you look that up in court terms, that means not reasonable or reasonably explained. The EPA comes back and argues that, the rule, we'll call it the FIP, could continue to be implemented without regard to the number of states. Essentially some states could drop out. But the court said, no, we're going to stay the EPA's enforcement of this rule, send it back to the lower court, and it can come back up at the appropriate time. So that's sort of the I didn't weigh into the whole, again, that's the nature of this good neighbor plan. It's sort of, states must design these plans with their neighbors in mind. That it's sort of a strange sort of commandment that is open to a lot of discretion and therefore a lot of mischief. I'm interested in your thought, because I first said, let's drop this case because we got other stuff going on, bigger fish to fry, but you really wanted to talk about it. So,
well, I mean, I think I found it interesting for a number of reasons, but just on the facts, the EPA, when these states submitted their good neighbor provisions, which I think is a very sensible thing, because if you are a downwind state, as it were, you're saying why should I have to meet these standards when so much of the pollution in my state is actually coming from this other state polluting. That doesn't seem to me unreasonable.
Yeah, no, it's fair. Yeah.
Yeah. So, and so the states have to submit their plans, and the EPA looks at them and says, well, is this reasonable? If not, then we'll put you under our own federal implementation. I think it's federal implementation plan. And in fact, I think they rejected the plan of 23 states. But after that, these states said, well, no, this is a pretty good plan. And in fact, courts stayed 12 of those 23 disapprovals, right? And so I think that the remaining states were like, wait a second. So you just put in this blanket plan for all of us, but now that like half the states are out of it, how can this still be workable? And explain yourself, EPA.
Right. And the EPA did not, or I should say the Supreme Court said that the EPA was unlikely to be able to really explain itself well, but go ahead.
Right. But to me, what makes this important, why I think the dissenters got right, is that they looked to the statute, as you should do, right? And there's a part of this statute called the harmless error rule. And the harmless error rule says that the court may invalidate this rule only if the errors were so serious and related to matters of such central relevance to the rule that there's a substantial likelihood that the rule would have been significantly changed if such errors had not been made. In other words, how I read this and how dissenters read this is it's unlikely that further explanation from the EPA would have required or led to a significantly changed federal rule. So it's not enough to say, well, the EPA didn't do a good enough job of explaining because of this harmless error rule. And so the problem I had with this, maybe one of the reasons I wanted to talk about it, is because I don't like judicial activism. To me, this is another win for judicial activism where the majority on the court, ignored an important part of the legislation because they wanted to stop this good neighbor plan that was imposed by the EPA from going into effect in these states. And I think kudos to Justice Barrett for siding with the court's three liberals on this. And I will point out also, I wanted to say that Justice Barrett has been kind of interesting, I think, in some of her decisions. She is certainly not the complete right-wing theocrat, conservative activist sort of person that maybe some people hoped they were getting. And in this and a number of other instances, she's pleasantly surprised me.
Right. Well, Mike, she may be, as Ken would say, she's just trying to lure you into complacency. Then she'll really whack you next week.
Yeah.
So, look, I mean, maybe you and I have different takes on this because I first looked at this, and I still do, as this is a question of can the EPA enforce this rule against these folks while they're still waiting a review in the D.C. Circuit and likely another writ of cert to the Supreme Court on the merits of that. So I think, I look at this as much more procedural than you do. And it kind of goes to, I guess sort of the likelihood of the merits, the success on the merits. But yeah, I think telling the EPA, hey, you ought not to enforce these rules against half these states, right? When the whole idea is it doesn't make sense unless it's everybody. Pending review of the court, that seems to be pretty sensible to me. And I would say the activist thing is sort of weighing in and saying, look, we think the statutes could go ahead and enforce it, considering that it may be certainly unfair to some of these states who have to take on these burdens while other states do not.
Well, I think we need to obviously consider the court.
To me, the stay preserves the status quo, which is what you ought to do pending review.
Well, I think certainly you need to consider likelihood on the success of the merits, and you and I disagree on that. I think, And so, but there's also the question of irreparable harm. There's the question of balance of equities, which basically means, well, what's the harm to the party requesting the stay if it's not granted compared to the harm to the party opposing the stay if it is granted? And then finally, whether or not a stay would serve the public interest. And when I look at all four of those things, I find myself very squarely on the side of the four dissenters here.
Okay. And again, I guess this is one where I'm just not seeing it. And again, we're talking about a stay, not the merits of it, because again, the merits are going to be decided by the DC Circuit and then perhaps eventually the Supreme Court when it gets back up here. So I guess that's.
I guess when I look at the balance of equity,
I wish I had more to say on this, but I like I said, I was sort of like, well, I don't know. Do we really want to talk about that?
Well, you don't really think pollution is an issue, though. So,
What's that?
Well, you said you don't really think pollution is an issue.
If you want to say, is it irreparable harm that these states could maintain their emissions that they had before? I wouldn't think so.
Well, when I look at the balance of equities,
there's always an argument. Well, if it's the statute can't take effect, that's irreparably harming someone. But no, I'm not.
When I look at the balance of equities and serving the public interest sort of issues, as well as the likeliness and the merits, that's why to me this is an easy one. I think the court got it wrong in a big way on this one.
Okay, but look, the good news is everybody's going to get a couple more chances at it. Yeah,
and then they're going to get it wrong in the end anyway.
And be able to really dig in on have a full record, right?
Yeah. No, absolutely. So
that's kind of where I come down, is that this is not that big a deal. Again, you got some differing opinions, but it's based on a partial record, and let's let the thing play out.
Okay, well, that's exactly what will happen. So let's move on to another Supreme Court case. Yes, there's yet another one, and the question here is, well, when is a bribe not a bribe? And well, when it's a gratuity, I guess, according to 6 justices on the court, right? This was a ruling that said essentially that an anti-bribery law doesn't apply to anything of value given to a public official after an official act that makes it a gratuity. And the case involves this guy, James Snyder. He was the mayor of a small town in Indiana. When he was mayor, the city awarded just over $1 million in contracts to a local trucking company. Then the next year, the company gave Snyder $13,000 for quote unquote consulting services. Maybe it was, maybe it wasn't. The jury didn't buy it. The FBI didn't buy it. He was convicted, but it was the statute that he challenged, saying, well, wait a second, I got a gratuity and I was convicted under a bribery statute, and that's not okay. If they wanted to convict me, they should have convicted me on a gratuity. And the majority of the court said, well, yeah, that's right. In the opinion, which Justice Kavanaugh wrote, he made the point that there are separate anti-bribery and anti-gratuity laws, and they're different crimes with different penalties, up to, on the federal level, up to 15 years for accepting a bribe, just I think 2 for a gratuity. And of course, well, given that, if we look at the language of the statute in this overall context, it doesn't make any sense. And if Congress wanted to, it could certainly change the law to make it clear that this is a gratuity and bribery law, but it didn't do that. It hasn't done that. And as Kavanaugh writes, this is presumably because Congress understands that state and local governments may and often do regulate gratuities to state and local officials. Now, the dissenters, this was Justices Jackson, Sotomayor, and Kagan, they went to the text of the statute and they said, well, wait a second, the statute uses the term rewarded. And Justice Jackson says, well, the term rewarded easily covers the concept of gratuities paid to corrupt officials after the fact. After all, that's what a reward is, getting something after the fact, and that the majority basically all but ignores this inconvenient word until the very end, at which point they, in Jackson's words, offer rank speculation as to why the word might mean something other than what it ordinarily does. So, Jay, what do you think about this decision?
I think the majority probably got it right. There's what's called in criminal law, and one of the concurring justices points out, the rule of lenity, which means if there's a way to interpret the statute in favor of the criminal getting off, then that's what you do. It's sort of a keystone of our civil rights, right? The idea that the government has to prove every element beyond a reasonable doubt. And look, if there's any question, ambiguity goes to the defendant. So I think read in that light, I think they probably got it right. I guess, again, it sounds like, again, this is one you have stronger feelings than I do on this one.
We hope you enjoyed this preview of our supporters-exclusive midweek show. If you'd like to hear the rest of the episode, we hope you'll consider becoming a supporter. Supporters get ad-free access to all of our shows, membership in our Politics Guys Discord group where you can join in on the conversation, and other benefits at different levels of support. To become a supporter, go to patreon.com/politicsguys. You can also support us through Venmo or @politicsguys or through PayPal. You'll find all of our support links in the show notes as well as at politicsguys.com/support. And if you'd like to get the midweek show, but you're not in a position to become a financial supporter, that's not a problem. Just send me an email at mike@politicsguys.com, and I'll be happy to get that set up for you.
This podcast is part of the Democracy Group,